Good morning and greetings from the United Nations in Vienna. My name is Martin Falk, and I apologize for the slight delay in starting. I lead UNODC's normative and policy function on human trafficking and migrant smuggling, which this week supports annual meetings of international intergovernmental working groups on the smuggling of migrants and trafficking in persons, which bring together almost 1,000 registered delegates throughout the course of this week. I will be moderating this session today, which we will very quickly get to, but let me please first note the following. Today's event will be conducted entirely in English. It is also being recorded and will be made publicly available. And lastly, there will be time for interaction with our expert speakers after each panel has spoken. So please do not hesitate to use the chat function to raise any questions for our speakers, either in writing or orally, kindly indicating your institution or country. This event is the first of two we are convening this week in addition to the formal meetings to provide additional discussion spaces for those gathered. Today's event brings together a group of speakers and panelists defined by their knowledge, proven expertise, and readiness to discuss the challenges of either giving meaning to a principle of non-punishment of trafficking victims or lessons learned at the country level in progressing investigation of migrant smuggling. Our objective in convening this event is to support and stimulate those who gather here in a more formal setting to focus on key current issues, but perhaps more so to mobilize an increasingly engaged community of stakeholders who want to do better, who want to bring positive change to the human suffering caused by human trafficking and migrant smuggling, such as the emerging tragedy in the US, where almost 50 people were found dead in the back of an abandoned truck yesterday. That is the reality we are facing. That is the reason we need to do better. In the first part of this event, operationalizing the principle of non-punishment of victims of trafficking, we welcome three expert speakers: Dr. Marika McAdam, independent expert on human trafficking; Professor Siobhan Mullally, UN Special Rapporteur on Trafficking in Persons, especially women and children; and Ms. Marija Andjukovic, Director of the NGO Astra from Serbia. In the second part, lessons learned and best practices and national procedures to investigate the smuggling of migrants, we will hear three expert presentations from Mr. Muhammad Tahirai, Director General of the Federal Investigation Agency of Pakistan, a joint presentation from Mr. Selbal Langi, Prosecutor with the National Agency for the Prohibition of Trafficking in Persons of Nigeria, and Mr. Andover Couture, Expert Consultant with UNODC in Nigeria. And finally, Mr. Greenwell Liempe, currently Zambia's Deputy Ambassador to Egypt. Welcome to all. A small reminder to speakers to please keep to your allotted time so we ensure we have time to address the questions raised by our audience. To help ensure such, I will give you a reminder 1 minute before your time is up. I now turn to our first topic and speakers. While the Trafficking in Persons Protocol does not explicitly provide for the non-punishment principle, there is increasingly widespread acceptance that punishing victims of trafficking for offences they have committed as a consequence of being trafficked is unjust. However, in 2022, the effective application of this principle by states is uneven at best across countries, across regions. Why is that? Without further ado, I now give the floor to our first speaker, Dr. Marika McAdam. With great pleasure, Dr. McAdam, please, you have the floor.
Thank you so much, Mr. Falk, for the invitation and the opportunity to be here. It's a pleasure to see you as always. I would like to use my time to speak on the basis of a study published with the ASEAN-Australia Counter-Trafficking Program on this very topic. The study is very new. It was just published in March. and it benefited from wide consultation across the ASEAN region and indeed beyond, including from Professor Mullally, who I'm delighted to see here today. The study offers 26 recommendations. I'm obviously not going to go through all of those now, but I do encourage you to consider them as you deliberate on this important topic. ASEAN, I think, is a particularly insightful region given the wide commitment to it. There's an explicit provision on non-punishment in the ASEAN Convention Against Trafficking in Persons. There's several bilateral agreements that explicitly speak to the principle, and indeed 7 out of the 10 ASEAN member states have a non-punishment provision in their legislation. But unsurprisingly, as in all things counter-trafficking, there still remains challenges with operationalizing that commitment into practice. So I'd like to speak to that fact and the reality that across the region, victims, including children, may be prosecuted for a range of offences and unlawful activities, including immigration-related offences through to prostitution and drug-related offences, and indeed other unlawful activities, including labour violations, IUU fishing, organ removal, and I think indeed the rise of trafficking into online gaming and call centre scamming will raise particular concerns with respect to punishment for fraud and cybercrime too. So this is an acutely concerning issue. So in the time available to me, let me speak on some of the challenges that present and how we might go about addressing them. First of all, quite obviously, there's lack of awareness of the principle, and secondly, lack of ability to apply it. And that can range from total ignorance to the existence of this possibility of not punishing victims for unlawful activities, through to knowledge of it, but lack of confidence in applying it. In reality, practitioners may be more comfortable with applying provisions that exist in the criminal code than they are to applying protections that exist in the anti-trafficking law. Related to that too, practitioners may be incentivized to lay charges against offenders, but not incentivized not to prosecute them. So how do we incentivize practitioners to apply this principle and to exercise any discretions that they may have when they encounter offenders who may actually be victims of trafficking? And at the more granular level, we have confusion about which model to apply and how indeed that's applied. Some countries take a causation-based model, some a compulsion-based model. And in both of those, questions arise depending on the context, who is being asked to consider its application, and how to establish the nexus between the traffickers offending and their trafficking, and indeed, when does that nexus end? Across all countries, irrespective of which model applies, whether duress-based or nexus-based, there seems in practice to be a prevailing view that the type and gravity of the unlawful act is determinative as to whether a victim should be punished or not. Now, that is not helped by laws and bilateral agreements that contain exhaustive lists of offences to which the principle applies, to the exclusion of others, and that there is a view in practice that there must be some degree of compulsion. This risk is exacerbated where there are hostile policies towards migrants, resulting in victims being seen primarily as irregular migrants rather than as victims, or indeed where there are wars on drugs being waged such that victims who are trafficked into the drug trade are seen first and foremost as offenders rather than as victims. And here, of course, we must pause to contemplate the ramifications of corporal and capital punishments, which means that it's no exaggeration to say that the application of the non-punishment principle is a question of life and death for some victims of trafficking. But before we can even unpack those models and the complexities of application in practice, we have to first identify victims. And here is a significant challenge to the application of the non-punishment principle. Identification of victims of trafficking remains fraught particularly where practitioners on the front lines encounter them as potential offenders. And the risk of non-punishment is exacerbated in certain contexts, such as raids, where practitioners will rely on victims to self-identify, which we know from practice around the world that this is so rare. And the reality that follows from this is that once a victim enters into the criminal justice system as an offender, they are very unlikely to be identified as a victim thereafter. And this speaks to the role not only of law enforcement and immigration and labor officials, but also to prosecutors, to defense lawyers, to members of the judiciary, to ensure that they have the requisite skill set to identify a victim of trafficking in the offender who stands before him or her in the criminal justice system. And again, as ever, all of this rests on the capacity of criminal justice practitioners to understand the definition of trafficking in persons, to understand the interplay of the constituent elements of that offence, and to understand complex issues like the irrelevance of victim consent where means have been used, and to apply all of this in the application of the non-punishment principle, for instance, to ensure that compulsion is broadly understood to capture all of the means in the definition. So against the backdrop of that quite complex list of challenges, I'd like to end on quite a simple point. The non-punishment principle is, of course, not a blanket immunity or a carte blanche for victims of trafficking to engage in unlawful activities. There will, of course, be circumstances in which it is entirely appropriate to punish a person, even though he or she may be a victim of trafficking. And so, where a victim of trafficking has been involved in unlawful activities, it is imperative that the state is able to explain how they have applied the principle and given due consideration to its application, and why, in that instance, the determination was made that an individual victim should not benefit from the non-punishment principle. And importantly, that determination should not be made purely on the basis of the type or the gravity of the unlawful activity involved. Now, to achieve that safeguarding, of course, states must equip practitioners across the criminal justice system, and beyond counter-trafficking actors. Indeed, we are asking those who encounter offenders of all sorts of crime types and unlawful activities to be tuned in to the possibility that among them may be victims of trafficking. So our capacity building commitment has to spread broader than it currently has been. Those practitioners need to be provided with clear and accessible laws and policies, as well as guidance that is both context and user specific, so that they are able to identify potential victims of trafficking among the offenders who they encounter, who indeed may be involved in serious offences. I will leave it on that note, Martin, with thanks very much for people's time and attention.
Thank you very much, Dr. McAdam, Marika, for those very rich points. And I would highly recommend the report to all for further reading. We do have time, as I said at the start, for questions for Marika and our other experts coming. So please do note those questions in writing if you like now, or we will have some time for people to make those as well orally. It's now my very real pleasure to give the floor to Professor Siobhan Mullally, the UN Special Rapporteur on Trafficking in Persons, especially women and children. Professor Mullally, we're very, very glad to have you here. You have the floor. Thank you.
Thank you very much, Martin, and thank you to colleagues for the opportunity to present at this important meeting. And to try to support the work being done in progressing the principle of non-punishment of victims of trafficking and its more consistent application and implementation in practice. My remarks will draw on the report that I presented to the Human Rights Council in 2021, which goes into more depth specifically on the non-punishment principle. Although it is not stated explicitly in the Palermo Protocol, the non-punishment principle is essential to the object and purpose of the protocol, and specifically to ensuring and protecting the human rights of victims of trafficking. Punishment of a victim marks a rupture, a break with the commitments that are made by states to recognize the priority of victims' rights to assistance, protection, and to effective remedies. At its core, it's aimed at ensuring that a victim of trafficking is not punished for unlawful acts committed as a consequence of trafficking. And given the trauma already endured and the fear of reprisals by traffickers, the added fear of prosecution and punishment only further prevents victims from seeking protection, assistance, and justice. I think it's important that we also remember that punishment of victims also undermines the fight to combat impunity for trafficking in persons, because it is targeting victims rather than perpetrators. Therefore, it limits both the effectiveness of investigations and the promise of accountability. A commitment to the non-punishment principle is found in several international instruments. The UN Security Council has repeatedly called upon states not to penalize or stigmatize victims of trafficking for their involvement in any unlawful activities. In its general recommendation number 38, the CEDAW committee has reiterated the importance of the non-punishment principle and the obligation of states to ensure its application to victims without exception. So that is important to remember, that core commitment to non-discrimination, to ensuring application of the principle without discrimination. We know that failure to respect the principle of non-punishment leads to further serious human rights violations, including arbitrary arrest and detention, forced returns and refoulement, arbitrary deprivation of citizenship, debt burdens arising from the imposition of fines, family separation, and unfair trials. So ultimately, punishment hinders the possibility of recovery and is a denial of access to justice for trafficked persons. As I said, it also limits the effectiveness in investigations and prosecutions and limits the effectiveness of prevention programs and measures. And recognizing this, the Global Compact on Safe, Orderly and Regular Migration calls upon states to facilitate access to justice and safe reporting without fear of detention, deportation, or penalty. As we heard, however, despite these repeated calls, the implementation of the non-punishment principle by states has been limited, and its scope and content continues to be contested. It is set out in more detail in the principles and guidelines of the Office of the High Commissioner for Human Rights on human rights and human trafficking. The General Assembly in 2011 affirmed the non-punishment principle and urged member states to refrain from penalizing victims who had been trafficked for having entered a country illegally or for having been involved in unlawful activities that they had been forced or compelled to carry out. We also have reference in the 2014 protocol to the ILO Forced Labour Convention, which requires states parties to take the necessary measures to ensure that competent authorities are entitled not to prosecute or impose penalties on victims of forced or compulsory labour. And several regional legal instruments include references to the principle of non-punishment. Marika has already referenced the ASEAN Convention. We also have references in the Council of Europe Convention on Action Against Trafficking in Human Beings and the EU Directive. And very importantly, the European Court of Human Rights, in its landmark judgment on Article 4 of the European Convention on Human Rights and Article 6 of the Convention, which is the right to a fair trial, the court there recognized that the non-punishment principle is incorporated within Article 4, the prohibition on slavery, forced or compulsory labor or servitude, and is a requirement also of effective protection of the rights under Article 6, the right to a fair trial. The African Committee of Experts on the Rights and Welfare of the Child has repeatedly called upon states to ensure that children trafficked for purposes of forced criminality, exploitation, and criminal activities are treated as victims and not criminalized. Importantly, however, I think a key concern that we need to recognize and openly address is that there is a failure to ensure the principle of non-discrimination in international human rights law, which is a core principle and is critical to the principle of non-punishment. However, we know that discriminatory attitudes and practices in investigation, in prosecution, in protection, in identification continues to hinder the identification and protection of victims. So those who are at greater risk of punishment, victims of trafficking at greater risk of punishment, are also those who are particularly vulnerable to exploitation, to trafficking and to re-trafficking. So we need to recognize and acknowledge the intersections of gender, race and ethnicity, migration status, poverty and disability in failures to identify victims of trafficking as such, and in failures to ensure the effective application of the principle of non-punishment. And I just want to note briefly the importance, because I don't think we talk enough in anti-trafficking forums about disability inclusion. We need to ensure disability inclusion. We need to ensure effective application of the principle of non-punishment to all trafficked persons with disabilities. And this is particularly urgent where persons with disabilities may be at heightened risk of exploitation, including for the purpose of forced criminality. So are our procedures, are our processes compliant with international human rights standards with regard to the rights of persons with disabilities in terms of thinking about legal capacity, legal assistance, reasonable accommodations to participate in legal processes? The European Court of Human Rights particularly emphasized the link of the non-punishment principle with the right to a fair trial, and pointed out that states' positive obligations to identify victims of trafficking meant that it could not be argued, as was attempted in this case, it could not be argued that it was the defendants who were at fault in not informing police or legal representatives that they were victims of trafficking, particularly where they are children, as in this case, they were at the time of being trafficked. So it's important to the protection of the right to a fair trial, it's important to protection and assistance to victims, and critically important to ensure effective protection of the rights of the child. Questions arise as to the scope of the non-punishment principle, and this is where we often have discussions and contestation and debate. Ensuring a comprehensive response to human trafficking requires that the non-punishment principle is applied to unlawful acts, to be understood broadly as including criminal acts, immigration, administrative or civil offences. It is not limited to status-related offences only. And this again has been recognised in the General Recommendation number 38 of the CEDAW Committee, which calls on states to ensure non-punishment of victims for irregular entry or stay in context of absence of documentation, or for their involvement in unlawful activities to the extent that such involvement was a direct consequence of their situation as victims of trafficking. So the use of the term unlawful activities recognises its application beyond involvement in criminal activities. And we also need to recognise the link with Article 31 of the Convention relating to the status of refugees, the 1951 Refugee Convention. Article 31 protects refugees from being penalised for illegal entry and presence, and is applicable to trafficked persons who may be entitled to refugee status or other forms of international protection. The question then arises also around scope concerning the gravity or seriousness of the unlawful act or offence committed. And the effectiveness of the non-punishment principle is hindered, its implementation is hindered and limited if we confine it to minor offences only. Greta, the Council of Europe group of experts on action against trafficking in human beings, has repeatedly recommended that the non-punishment principle be applied to all offences that victims of trafficking were compelled to commit, and has recommended the removal of exceptions. According to the OSCE recommendations, the duty of non-punishment applies to any offence so long as the necessary link with trafficking is established. The Special Representative of the Secretary General on Children in Armed Conflict has highlighted states' legal obligations not to doubly victimize children who have been abducted, recruited, used, and exposed to violence at an early age, and to ensure that all children associated with parties to conflict and encountered in security operations should be treated primarily as victims rather than as security threats. And I really think we need to pay attention to trafficking in persons in conflict situations and to how the non-punishment principle applies in these contexts. Addressing trafficking in situations of armed conflict and in post-conflict situations in its resolution 2388, 2017, the Security Council urged member states to refrain from the use of administrative detention of children, especially those who are victims of trafficking in persons, for violations of immigration laws and regulations. Security Council Resolution 2427, 2018, applicable to the treatment of children associated or allegedly associated with all non-state armed groups, including those who commit acts of terrorism. There, the Security Council called for the establishment of standard operating procedures to ensure that children were handed over to civilian child protection actors and provided with assistance and protection. In terms of the range of forms of punishment, I think here also we need to be comprehensive in how we look at how the principle applies and what forms of punishment may be applied to victims of trafficking. They may include exclusion from refugee status, denial of other immigration relief, arbitrary deprivation of nationality, citizenship stripping, termination of social welfare benefits or denial of social security payments, restrictions on movement, detention, or other undue restrictions on liberty, including also non-repatriation of victims of trafficking, refusals to provide consular assistance, imposition of travel bans or confiscation of travel documents, or refusal of entry into or transit through countries. So we need to look at and engage with the range of forms of punishment. It is important.
Nalali, with apologies, one
I
minute.
will conclude. Yeah. Oh, thank you. Yes, thank you. And to conclude, I am actually just about to conclude. One of the key questions which Marika already alluded to was the question of what is the link, what is the nexus that is required? And in my report to the Human Rights Council, I have highlighted that the causation criterion has a merit of highlighting that the offence committed by a trafficked person may arise as a result of their lack of independence or ability to exercise free will, and that this may be over a period of time. The risk of continuing psychological and physical abuse may not give rise to an immediate cause of harm, but reveals or highlights, I think, the more complex impact of the trauma endured. And here I think it's critical that we recognize that inconsistencies in a trafficked person's testimony, particularly for a child, but also for adults, that this should not undermine or determine the outcome of an assessment of status. And in the practice, in the implementation, we need to ensure that a guilty plea can be vacated. We need to ensure that proceedings can come to an end and be stopped where they have been initiated. And we need to ensure that any records, criminal records or other records or sanctions that have been imposed, that these can be expunged and vacated, and that legal assistance is provided and ensured to achieve that. Otherwise, we risk trafficked persons continuing to bear the burden of the imposition of these sanctions or holding criminal records, and that inhibits and hinders the possibility of recovery and establishing a new life. Thank you. Over to you.
Thank you, Professor Nalali, very, very much for your presentation and all the work that you continue to invest over a prolonged period of time on this issue. I'm very happy to now give the floor to another invaluable expert, Ms. Marija McAdam, Director of the NGO Astra from Serbia. Ms. Andrikovic, thank you for joining us. Please, you have the floor.
Thank you, Martin, for the invitation and possibility to share our experience from the field regarding the topic of non-punishment provision implementation. My organization, ASEAN Anti-Trafficking Action, is working for the last 22 years in the field of combating trafficking in human beings with regard of direct victim assistance, but also prevention education and policy changes for full implementation of victims' rights. In the last 2 decades, we witnessed several times on wrong implementation of non-punishment provision, which led to sometimes really traumatic experiences, not only for victims and their families, but also for my staff who tried to help them during many years reaching the justice, but at the end not succeed to do it. I will mention 2 cases that will show how the wrong implementation of the non-punishment closure in principle could influence the whole life of the victim and their families. The first case is the case of a young woman who was recruited to the trafficking chain by the lover boy method, and who was sexually exploited and labor exploited for many years. While being trafficked, she was forced to commit criminal acts, different criminal offenses for her perpetrator. After he committed the murder of his co-worker, he blackmailed the victim to take the responsibility for that murder, or he will kill her daughter. After, at the end, she take the responsibility for this murder, and she was convicted to 18 years and 6 months of jail for the murder of the co-worker, his co-worker. And only after the judgment became final, she asked for the assistance from the NGO. Astra is still providing psychological and social assistance to this woman and material assistance to her family, her daughter, who is still in school. And every year we are still asking and hoping for the New Year's abolition by the president for this victim. I should only say that we are doing this together with the State Institution Center for Victims of Trafficking, because they identified this victim officially as a victim of trafficking. In the second case, the young man was trafficked for the purpose of committing criminal offenses together with several girls who were sexually exploited by the same trafficker. Most of them, they have family issues that was used very smartly by the trafficker, and they were kept locked and isolated in the apartments, and they need to give all the money earned in this way to the trafficker. After exchange office robbery, he and the trafficker himself, they were arrested together, and the boy was told by the police and the prosecutor that he will get the lower sentence if he admit all. So he did it in front of the trafficker, and he was convicted to 1 year of jail. And then he realized that he will probably serve the sentence together with the trafficker in the same jail. And that was the push factor for him to ask for assistance. Unfortunately, in both of these cases, the judgment was final. So when the Republican prosecutor office was involved and willing to help, it was too late. And the extraordinary remedy was refused by the Supreme Court. So the irony is that after our client served his sentence and start to coming back to the normal life, or so to speak, start with reintegration. So he finished the school, he started his own family, he found a job. He got invitation for the court because the prosecutor who made a mistake decided to press charges against the trafficker, and he invited our client to be the witness in the main witness in this court process, which lasts now for 9 years. And I must say it's really slowing down our client in the reintegration process. So what is common for both of these cases is that at the beginning, these persons were not recognized by the first respondent officials as victims of trafficking, but afterwards, in both cases, a Republican prosecutor office was willing to help and to support them, imposing extraordinary remedies, unfortunately with the negative decisions of the Supreme Court. In the root of all these cases actually is, and it is in relation to the issue of criminalization, which is the topic, our topic on Friday as well, is the principle of non-punishment. And essence of this principle is proper, effective, and timely identification of victims of trafficking by the first responders like NGOs, police, prosecutors, lawyers, defense, ex officio lawyers. Do not forget that victims usually they cannot afford lawyers. So usually trafficker is paying for their lawyer, or they get ex officio lawyers, and medical staff as well is important to be involved in this early identification. Due to the violation of this non-punishment principle, apart from injustice, victims can suffer severe consequences, like being in jail with their perpetrator, being deported, or lose a various spectrum of rights that they have according to the international and national documents. This is why it is really important that on the first credible signal or suspicion that we have a potential victim in front of ourselves, this victim potential victim need to be safeguarded and not prosecuted or convicted like in these cases. And I will finish with 3 recommendations. There are many recommendations regarding non-punishment, but I think these 3 are really urgent and important. The first one is that obligation not to punish victims of trafficking, grounded in the international law, must be effectively implemented by the states in their criminal systems and practices. In other words, from our experience, recommendations, guidelines, and standard operating procedures are not enough. We need to see non-punishment principle in the law, in the criminal or other laws. The second thing, and it's also mentioned by previous speakers as well, so I guess it's important then, and that is that early screening by the first responders is really important, as I already said, by police officers, prosecutors, judges, NGOs, medical staff, ex officio lawyers, and so on, defense lawyers. General trainings, we are talking a lot about your trainings, and we are implementing many trainings, but on general trainings, we mention non-punishment principle only several times. That's really not enough. We need advanced trainings with practical exercises and indicators how to recognize victim of trafficking, even she committed a criminal act. It's important also to include in these trainings not only police officers dealing with serious criminal acts like trafficking, but also those dealing, for example, with property crimes, especially those dealing with children and minor offenders. As we know, children are very often used for this type of trafficking, like committing a criminal act. And last, but not less important, definitely, victims should not be restricted in their access to residence or other rights that are prescribed by international laws, which means that us from NGOs, but also other service providers, should not be pessimists and stop providing assistance to victims, even if we didn't manage to do anything at the end with proper legal support. We should continue providing psychological and social support to the victims of trafficking and their families. Thank you.
Thank you very, very much, Ms. Nikovic, for the reality check and talking about specific individuals and the terrible situation they have gone through and continue to suffer from. I'd like to thank all of our experts who have spoken so far. As we noted, our time is tight this morning, but we do have time for some questions from our experts on everything that they have laid out before you. I understand we have one question online. Can I just ask if there is anybody who is joining who would like to ask a question directly to one of our experts about any aspect of what they've talked about today. The conversation has been rich. Unfortunately, and I apologize again to our speakers, it's been brief to ask you to cover so much, that what you have offered provides so much to so many. And again, I would just ask if anybody would like to ask a question now. If not, I give everyone a chance to catch their breath, to maybe reflect a bit more, and we will move on to our second group of speakers, and come back. Hopefully, if others are able to stay online, Professor Mullally, Dr. McAdam, and hopefully we can come back to you before we finish at 10:30. Thank you. So we now move to the second part of this event, focusing on lessons learned and best practices in national procedures to investigate the smuggling of migrants. As will be increasingly asked in the international media today, what is being done to investigate those who smuggle people, with often the most callous disregard for their lives and safety of people who are essentially desperate? Greater knowledge and understanding of national procedures and investigatory approaches, the successes and challenges for our peers in other countries is vital to improving the efforts of all and improving the international cooperation, which is key to having any lasting impact on migrant smuggling. I would now like to sincerely welcome and give the floor to Mr. Mohammed Tahir Rai, Director General of the Federal Investigation Agency of Pakistan. Tahir, you have the floor. Thank you.
Thank you, Martin, for giving me an opportunity to tell you something about the investigations into migrant smuggling in my country, and the challenges we are facing and the successes we have. Next slide, please. Yeah, thank you very much. Basically, we are a unique country from the point of view that we are the origin, transit, and the destination country. Agents and criminals, they have nexus with the transnational organized gangs, and their modus operandi is what in other countries also there, that they lure victims, showing them the future dreams. But they earn money and exploit the victims, considering them a commodity. And mainly they use the land routes, but not excluding the sea and air routes. And interestingly, these days they are using encrypted apps, and it's very difficult. That's why to collect the evidence or connecting them with the crime. Well, there are push and pull factors. The push factors are that there is poverty in the country that pushes people. There is unemployment, and especially in the wake of COVID-19, job opportunities have decreased. Then there is lack of skill and info to use the legal migration channels. That's there. And the pull factor is demonstration effect of a bright future in rich countries, and there are more economic opportunities in those countries. This background was essential to be told before discussing the problems in investigation, in fact. So when now the stage is set for that, I wish to share with you the approaches in prevention and detection of this crime. We use two main approaches to curb these offenses of migrant smuggling. First, the interceptions are made on the routes in border area regions, basically, and then we use intelligence within our organization. Intelligence-based operations are conducted to intercept the people, intercept the criminals who take the migrants to other countries. And secondly, we get information from the deportees of smuggling. When they are deported, we interview them and they provide us leads. Based on those leads, we identify and arrest the offenders. Then the offenders are investigated, and when we have evidence, they are prosecuted. Well, the new law based on a relatively new law is there, and we have made rules under that act, that is the Prevention of Smuggling of Migrants Act 2018. It's based on UN Protocol Against Smuggling of Migrants, and it provides for comprehensive definitions of the offenses. Punishments provided by this law are commensurate with the gravity of the offenses, and the aggravating offenses are taken into account for repeat offenders. And the principle of non-criminalization of the migrants protects the victims. Well, coming to the investigatory practices, training of investigating officers is the first sine qua non, because they must know the special skills to investigate these offenses. These are not normal offenses. Here we need to punish the offenders, but at the same time we have to protect the victims. So in this law, penal provisions are very simple. There's no confusion regarding culpability of the offenders, but at the same time, victims are protected and they are assisted in their rehabilitation. Mainly the agents are the offenders and they are prosecuted. Code of Criminal Procedure of Pakistan is applied in investigations and prosecutions. International cooperation is very important in this respect, and we get that. Existing cooperation mechanisms include bilateral focal points in partner countries. And then we use our Foreign Office channel, FIA link offices in various countries. They help the victims and help us collect the evidence against the offenders. And then we have liaison with our local police officers on case-to-case basis. Specific points of contact for identification and sharing of information are used, and the specific points have been established in our neighboring countries. And process is in negotiation with European Union for readmission of victims into Pakistan from there. Well, I want to share the case study. It's very interesting case study that in 2019, three females were transported and smuggled to UAE for employment. In fact, they were forced to indulge in prostitution. The report, when they reported to their family in Pakistan, the report was made to the local police in UAE, which arrested the accused. Pakistan Link Office in Oman played a pivotal role. The victims were repatriated. They were rehabilitated with the assistance of law enforcement agencies. The accused were investigated and prosecuted. The case got media limelight at that time in Pakistan, and that helped a lot to inform other victims not to be lured by the offenders in this respect. The other case study is a kidnapping for ransom case. In March 21, an illegal immigrant in Greece was kidnapped by some local people. The gang demanded ransom from the family in Pakistan. The family reported the case to FIA in Pakistan in Lahore, and the FIA contacted the Link Office Greece, which recovered the abductee. The accused were arrested both in Greece with the assistance of local police. The local gang members in Pakistan were also arrested, and the ransom amount which has been paid by the family in Pakistan to their accomplices in Pakistan was also recovered, and they were prosecuted in Pakistan. And again, the media was used for creating awareness to tell people not to get involved in such activities. Well, coming to my second last slide is the best practices and lessons learned from Pakistan. UNODC protocols compliant new law has started bearing fruit. New law provides for comprehensive legal framework now. In fact, we framed the law in 2018, just giving effect to all the recommendations made in the UNODC protocols. Focus has been on training and capacity building of the officers, because that can give us the benefit. Trained officers can investigate and prosecute the offenders. Then multi-agency approach is a new normal with us. FIA for investigation and prosecution and victim identification. We use civil society and media for awareness. International NGOs and local NGOs are used for victim support. Bilateral and multilateral cooperation is essential for effective response. Now coming to the recommendation, I want to recommend setting up of bilateral focal points for quickly sharing cross-border information to make effective investigations, ensure successful prosecutions. Because this is an area where we can get immediate results. And that's so essential in these days to collect evidence, in fact, because courts demand evidence, and that evidence can be collected by putting up focal points and sharing the information. Because we have seen that the information we got from our partner countries helped us in prosecuting our offenders in our country. So this recommendation is there, the setting up of bilateral focal points. Thank you very much, Martin.
Thank you very much, Mr. Rai. Thank you very, very much. I'd now like to pass to our next speakers. We have joint presenters. It's my great pleasure to welcome Mr. Sembol Langi, prosecutor with the National Agency for the Prohibition of Trafficking in Persons of Nigeria, NAPTIP, and Mr. Andover Couture, an expert consultant with UNODC in Nigeria. Mr. Langi, Mr. Couture, you're very welcome and you have the floor. Thank you. Mr. Langi, Mr. Couture, you have the floor, please. Sorry, we don't have any sound. Is your microphone muted? I'm sorry, we don't hear you at this end. There's no issue at this end. Could you please connect the... I'm sorry, we still don't hear you. Could I just suggest that maybe, just to give you a little bit of time, we can go to our next speaker and we will come back to you, if that is okay with you. Can you hear me? If it's okay with you, we will go to the next speaker and come back to you. So, Mr. Liempe, if it's okay, we would now give the floor to you, if that is okay with you. Thank you very much, Mr. Greenroll Liempe, who is currently Zambia's Deputy Ambassador to Egypt from Zambia. And Deputy Ambassador Liempe, you have the floor. Thank you.
Good morning, everybody, and it's a pleasure to be here and to make this short presentation regarding the lesson learned and the best practice in the national procedure to investigate smuggling of migrants, a case study of Zambia. I don't know if I may be allowed to share my screen from this side. It's indicating that my is disabled for the participants. I hope I can be allowed to share the screen so that I can share the screen on my presentation. Is it okay?
We're just enabling that now. If you just give us 1 second, please. Thank you very much. All done, please. Go ahead.
Due to time limits, I think I'll just quickly avoid some of the issues so that I at least stick to my 10 minutes time. Of course, I'll try to define what human smuggling is in Zambia from the legal point of view. And then I'll look at the lesson learned and best practice in the national procedures and the means to improve investigation or prosecution of migrant smuggling in Zambia. And of course, the national practices, challenges, and recommendations. And just to give you a clear definition of human trafficking in Zambia, the first part I think is a general point, general definition, but specifically again to the Zambian Anti-Human Trafficking Act. And by the way, the smuggling cases or smuggling matters in Zambia are still into the Anti-Trafficking Act. And of course, I'll be able to explain at the stage where we are to resolve this problem. And you note that smuggling means a procurement in order to obtain direct or indirect financial and material benefits of illegal entry of a person into the country to which a person is not a national or permanent resident. That's a definition according to the Zambian Act, which has been in existence, by the way, since 2008. It is one of the oldest acts in Southern African region. But to be more interesting is looking at the specific offense which creates migrant smuggling. And what is more interesting is section 1 of this act, which says that subject to provisions such as any person who smuggles another into or out of Zambia and participates in smuggling or consents to be smuggled commits an offense and is liable upon conviction to imprisonment for a term not less than 15 years or not exceeding 20 years. If you look at this is quite threatening because it means that even the people who consent to be smuggled, so it's either the smuggled and those to be smuggled can actually be punished. But that's the current law, but a lot is being done to try and change the situation. And of course, it goes on to show if someone has died, what happens, and subsection 3, this also indicates issues of fraudulent documents and so on. Of course, the process of smuggling is, as everybody knows, the migrant flees in desperate situation, the smuggler or the illegal entry arranges for an illegal entry, they are flown either using a plane, the journey they take, they use the boats, they are assaulted, they are raped, they're extorted, and upon arrival, there's no guarantee of their safety. Just a scenario of what happens, but I thought I should also just share you a few pictures of some situations where we have intercepted smugglers, and those are a few pictures. We see people in the boots, in the bonnet, in the engine, so they use all sorts of means. Some people are found they found in suitcases and all that. These are some of the few pictures I thought I should just share with you on the typical situation of smuggling of some of the cases which are intercepted in Zambia. Now, getting to the situation, of course, what have we learned is that how do we work to deliver the expertise, investigating people, building teamwork, and providing tools. I'll be able to get into details of this scenario put up in my next slide so that we'll be able to understand how it works to ensure that we work into fighting of smuggling of migrants in Zambia. Now, there are a few challenges, of course, we are faced as a country in terms of resolving this issue. As you know, that prosecution depends heavily on victims. And in most cases, these victims are never willing to cooperate with the law enforcement officers. And as you saw, that the law also criminalizes. So we have a situation whereby both the victims who are the victim of smuggling are not willing because they feel that if they come out open, they may also be touched. So majority of the migrant smuggling cases in Zambia are transnational. You note that Zambia is a landlocked country with about 8 neighbors, and you find that a lot of people who come through to be transit through Zambia are transnational. They come from different countries, as far as Ethiopia, Somalia, DRC, and many other countries. And the country is landlocked with 8 neighbors, and most of these borders are maybe regarded as porous because they're not completely closed and the border broad points are not everywhere. So most people can easily walk in and out of this country without less problem. So this entails that most smuggled migrants are not in their own country of origin. And the other problem we face is issues of language barriers. When most of these people are intercepted, we even have difficulties to get any information because they cannot even communicate because their languages is totally different from ours. Okay, and most of these are unwilling to cooperate criminal justice authorities, and also that they lack trust in these authorities and even to report these cases because they fear that they may be deported or prosecuted for other criminal activities. So these are some of the barriers and challenges we face as we deal with these issues. And of course, as another criminal justice system, the length of doing these prosecuting smugglers, it takes too long. And as we rely on the smugglers, we tend to have a problem in ensuring that we shelter these people. And in most cases, we find that these people can either be kept in prisons or some other places. Because currently, we only have few shelters which are used for victims of human trafficking, as opposed to the current scenario of victims of smuggling. So we have totally sufficient shelters. As we know, currently we have high numbers of smuggling cases, even opposed to human trafficking, because a lot of people use the country as a transit point, going down to south to looking for greener pastures. And there are always a lot of withdrawal of cases because most victims are not willing and are not ready to facilitate the whole process of prosecuting them, the people who were one. But what is the way forward? One of the things you have noticed, and with the help of UNODC, who have been so instrumental in helping, is that we are not who have to be effective in investigation is the fact that most law enforcement agencies in most countries or in the region at large do not make use of investigative tools. I noticed when the other colleague, my colleague presenter, was talking about issues of encrypted apps. These are becoming common, and we need to really find a way out of ensuring that our law enforcement officers learn to attend to some of these, understand some of these tricks which these people use, using encrypted apps and some other advanced systems. And also, most law enforcement officers in Zambia do treat smuggling cases as mere illegal migration and do not take them serious as organized crime. So in most cases, these people are just treated as prohibited immigrants, bundled up and deported. So in that case, you find that most smuggling cases are not taken at that level. So with the changes we're trying to make sure that these cases are well handled and a proper piece of legislation, would feel that we can make some good progress. Solutions. Of course, the solution is we want to ensure that there's no detention and criminalization of victims. This is very important because as long as the victims are detained and are criminalized, it will be very, very difficult for us to make progress. Okay? And also, investigation should be equipped with investigative tools, just to emphasize that we need to do victim-led investigations and multi-agent system. Because for us to get the sources of information where these victims are passing and to track their systems and so on, and the traffickers, who are sometimes mostly are the local people. Okay, most of the smugglers are actually the local people, because as the people reach the border, they'll find the local people who want to smuggle them in the country or make them transit through the country with other places. So we need to ensure that we work on the multi-agency intelligence, which need to approaches to bring together all law enforcement officers to work together. This is the this is the police officers, the guys who manage the borders, immigration, the police, the labor, and all agencies must be brought on board. Of course, we are also thinking of, and the process has actually started, of introduction of what is called the fast track and specialized courts. Because the victims of migrants smuggling, there are so many and they come from out of the country. If you are to use the ordinary court system, it takes too long, and some of them may be difficult where to keep them. So the best is that if you use the fast track court system, it will be able to conclude some of these cases within a space of time, so that at the end of the day, when smugglers are convicted, victims who are mainly from other countries can be repatriated back home. So this is working out and it's helped. And sometimes we are thinking of dealing with video conferencing on migrant cases, but that may be difficult, especially when these people are repatriated back home, that they may be linked up back to give evidence on a possible smuggler who has been involved. But it's something which is being worked on, and we hope that it can work out. Other recommendations are that no detention, of course, as I said, of victims. Investigation should be equipped with snapshot investigative tools. Lack of effective communication and cooperation among law enforcement officers there must be indeed some proper effective communication, because we realize that smuggling of migrants in Zambia and the whole Southern Africa is well connected. Because from the time when these people start their journey, they pass through so many countries until they reach their destination, where they hope to get the best out of whatever the journey is. So as law enforcement in the whole region works to cooperate, and I think at one time we had planned an exercise, the whole Southern Africa region, involving the map or the region where these migrants pass through, to try and trap the whole east route and see if we can work together as a matter of cooperation of law enforcement officers in the region, not only Zambia, because they pass through so many countries as they get to their destination, which is mostly in the southern part of Africa. And of course, we need to use the documentary and the forensic material evidence to be able to identify, because most of these victims of smuggling, they use very sophisticated documents. They use some of them fake documents, which might be very difficult to detect. So we are looking at a situation whereby these documents are well identified. It can help us a lot. Of course, our aim is to provision a safe shelter for all migrants who are smuggled. It is an uphill battle because the numbers are quite huge. You will note that, as I'll soon be giving you some few statistics, because the migrant cases, smuggled migrant cases, reach in thousands. So to have that kind of shelters may be a bit of a challenge, but we have, what is required is that this must be implemented. In conclusion, I wish to state that migrant smuggling is a crime which the police and border officers and health authorities and labor inspectors and embassy officials, which I'm one of them now, we need to work together to provide services or other persons who potentially could come into contact and cannot easily notice. If smugglers remain unprosecuted and innocent victims continue to be smuggled and exploited within the cross borders and within Zambia, this issue might not come to an end. So the network of employed migrants smuggling is to intersect with the global and regional rings that control the trade in other contraband such as drugs and all. Because as these smugglers move, they carry a lot of issues because they use the wrong routes. So they carry a lot of things. So we need to make sure that we network and work towards of course, the lack of accountability in law enforcement, and in fact, the smugglers will have a low risk of being seized and ensure that they are arrested. So we work together and we're able to account for all this. And just to give you a few statistics, I may not have indicated them here, but for now, the statistics I've just gotten back home that the cases of migrant smuggling are between January to date, we have had more than 1,200 cases of migrant smuggling. And the most common nationals are colleagues from the Horn of Africa, which is mainly Somalia and a bit of Ethiopia, and some neighboring countries which have that. But we have also noted that most people who are involved in these cases are the local people from Zambia, because are the people who knows the loopholes, the weaker points of the borders where these people are smuggled. And in most cases, their destination is not mainly to stay in Zambia. They always want to get to the greener pastures in the southern part of the region. And you find that they would want to rush there and settle and get work. So we've always been wondering what could be the most, but of course, as my other colleague did the presentation, there are a lot of pull factors where people are misled. They think that the better life down south, which may not be very true. So indeed, the issue of migrant smuggling is a problem, and we have noticed that Zambia is not spared from this. But to resolve the problem, which I just highlighted on the part of the law, I'm actually winding up, I hope I'm within time, that we noted that the mixing of migrant smuggling and the human trafficking was not a safe way. And UNODC guided us very well, and there were a lot of workshops carried out. At this point in time, measures have been put in place to extract or to separate issues of migrant smuggling from the anti-human trafficking realm. Because in the past it was mixing and it was very difficult to understand. But to understand the background where I'm coming from, that way back 2008, there was no much clear information in this area. But thank God UNODC did a lot to capacitate our law enforcement officers. And for now, they are able to clearly identify the distinction between the two. And that has helped us to separate. Currently, there's a bill which is being worked on. It was worked on with the help of UNODC, and draft has been put in place and is before cabinet for approval, and very soon it will be presented in parliament for possible enactment. So there will be total separation, okay? So our recommendation is that we really need to work together and ensure that migrant smuggling is treated as a serious crime, and indeed the perpetrators are easily identified and prosecuted. And we should also ensure that the victims are helped, because that has been the biggest problem. Okay, the criminalization of migrant smuggling is one of the things we have completely trying to get away with, because we realize that it is not helping in any way. But we'll try our level best. In the new act, currently there's criminalization, that I must agree. But there's a bill which is awaiting to be enacted, and it will soon be law, and all victims of smuggled migrants will just be treated as ordinary migration issues, and we mainly concentrate on the perpetrators or the smugglers. That's the current position. The law is changed, it's just waiting to be enacted. That's what I wanted to share you the case study of Zambia. related to this topic of lesson learned and the best practice for the national procedures to investigate the smuggling of migrants, a case situation of Zambia. Thank you very much for your attention.
Thank you very much, Ambassador. And thank you for being so open about many of the real challenges being faced. So we now come back again to our joint presenters. And Mr. Lange, Mr. Couture, I hope you can connect this time, please. The floor is yours. Thank you.
Good morning. Can you hear me now?
Yes, we can hear you. Thank you.
Sorry for that technical issue that we had. I will just quickly make 1 or 2 points and then hand over to my colleague Salvo, who will share with you real experiences and examples of what Nigeria has done in terms of successfully prosecuting migrant smuggling. The first point is that there is a difficulty in actually processing migrant smuggling. It tends to be processed as human trafficking in the countries that I have worked in. They understand it in the training room, they understand the differences, but this does not translate into actual implementation, such that even the language, the terminology you hear tends to describe in many respects human trafficking instead of migrant smuggling. So in the STARSUM project that I am involved in, we'll be trying to make these clarifications, and we have created a lot of awareness among law enforcement officials, and this is yielding some results. So in terms of approaches to investigations, most of the investigations happen as a result of interceptions at the borders. And then the officials do interviews, they deploy a range of investigative tools, searches, arrests, seizures, and all other tools to mainly reactive, to have statements from the witnesses and then make a successful prosecution. This morning I am in Benin City, Edo State, where I am continuing my mentoring activities, and I was informed that they had made their first referral of a case of migrant smuggling to the immigration headquarters in Abuja. So I'll be seeing them this morning, and it will be interesting to hear from their point of view the approaches that they took. So happily, somehow, in Nigeria, migrant smuggling legislation can be found in 2 laws, in the Nigeria Immigration Act of 2015 and the NAPTIP Act of 2015. So for now, immigration has not had any successful prosecution, but NAPTIP has, and you'll be hearing from my colleague shortly about the successes that they have achieved in this regard. In the case of Ghana also, they have said that they have treated migrant smuggling mainly as human trafficking. And because of the activities that we have carried out with them, they are now beginning to recognize the differences. And they say that in a short while, they will also come up with cases. One thing that is needed in both of the countries I'm working in is the establishment of procedures for investigation, because at the moment there are no procedures, there are no units. The units that you have incidentally bear human trafficking and migrant smuggling units. So you can see the attention on human trafficking as we have in these countries. So if my colleague Salvo is ready, maybe he can provide us with some of those examples from Nigeria.
Simba, we cannot identify you in terms of the participants. Can you maybe please indicate in the chat if you've joined under a different name, please? Or to raise the hand symbol if you're there, could you please either put something in the chat or just raise your hand? Thank you. Symbol, please go ahead. You have the floor. Thank you.
Hello.
Good morning. You have the floor.
Good morning. Hello, good morning. Thank you very much for the invitation, and thank you very much. Hello, can you hear me?
Yes, we can hear you. Please go ahead.
All right, thank you very much. It's a pleasure to be here, and thank you very much for the invitation to be part of this discussion. My colleague, Mr. Kutu, has given the background to the issues of migrant smuggling in Nigeria. And I have a presentation. I don't know if I'll be allowed to, so that I can share my screen.
Yes, you can. Please go ahead.
Thank you very much. So the background that has been given by Mr. Kutu, the nature of the cases we've had in the past, some come to us as a result of intelligence shared by other law enforcement organizations from other countries, or some of the victims and the smugglers were arrested at the point of departure. Another major thing we've noticed is that major kingpins or those facilitating smuggling of migrants reside outside Nigeria, usually in the receiving countries. So they have some other persons here whom they send money to facilitate the recruitment and the transportation of their victims to the destination countries. It will also be interesting to note that Nigeria is a source, transit, and a destination country for migrant smuggling. Now, another thing is that recently we've noted that most of the cases investigated involve the movement of children to join their parents or relations who reside in the receiving countries. For instance, some persons will have migrated out of Nigeria, and at the point of moving, they did not move through the legal way or through the regular way, so they couldn't travel with their children. They are now based in the countries abroad and want their children to join them. Another thing we've also noticed is that the use of resident card of an 8-month baby to move a 3-month baby to Spain. Then other issues, visa, birth certificate, marriage certificate, sometimes to even move the victim to their destination country. Sometimes they'll come with the name of maybe they are going for educational excursion or even issue of marriage. Now, here are a review of some of the cases we've done in the past. In this particular case, the Federal Republic of Nigeria versus Olaika Bello Taiwo, the defendant owns a school, and she arrived in the UK with 2 minors on educational excursion. But at the point of entry, the border officers raised issue of allegations of human trafficking, and they were denied entry. The case was referred back to us here in Nigeria, and we commenced investigation. The intention of taking the 2 minors to the UK was not just for them to go for educational excursion and then return back to Nigeria, but the intention was that they should join their biological mothers who are resident in the UK. After the conclusion of our investigation in this case, the defendant was convicted and sentenced to 5 years imprisonment without an option of fine on the 10th of December, 2018. Another case is the Federal Republic of Nigeria and Iseko John Porter. The defendant holds a Nigerian passport and a Spanish resident permit, and he's based in Spain with his family. The defendant and one other lady who is now late concluded plans in Spain, and they returned to Nigeria to perfect parental fraud and returned to Spain with the baby. The defendant in this case came to Nigeria with his daughter's travel document and Spanish permit to help in taking the 3-month baby back to Spain. The baby was born on the 25th of April 2019. The lady who is now late attempted to travel with the 3-month-old baby, but she was arrested at the Murtala International Airport because when you look at the baby, she was trying to travel with back to Spain. The baby was just 3 months because she was born in April and they attempted to travel sometime in July 2019. So you look at the baby that was on the travel documents, she was older, 8 months or thereabout. So it raises suspicion and she was arrested. And upon investigation, we realized that she was not the biological mother of the child that she was traveling to take back to Spain. In this particular case, the defendant was convicted and sentenced to 7 years imprisonment without an option of fine on the 3rd of June 2022. The court also made the following orders: that the Nigerian passport of the prisoner and that of his daughter are to be forfeited to the Federal Republic of Nigeria and returned to the Nigerian Immigration Service. The resident permits of the prisoner and that of his daughter used in perpetuating the crime were also forfeited as instruments used in the commission of the crime. Now, this particular part of the court order is interesting because under our law, all instruments used in the commission of the crime are to be forfeited and returned to the appropriate authority. But this will only be done because the defendants still have 90 days upon which maybe they will file an appeal. But if they've not appealed, the order of court will definitely be complied with. Another case is the case of Federal Republic of Nigeria versus Alatishe. Now, this particular lady, there's a lady that she's based in France. She contracted the defendant for smuggling of migrants and human trafficking to bring a victim to France. The lady in France processed the passport of the victim and used a different name for the victim. The defendant was with the victim all through throughout the process of processing the travel documents. The victim was arranged as the wife of the first defendant, and they altered her age from 25 to 40 years so that there will be no suspicion at the airport and maybe on in the destination country. On the 4th of January 2017, while at the airport, and the victim was just asked, what is your name? She could not even remember the names she claimed that were on her travel documents. So they were stopped from traveling. This one on the 17th of March 2021, the defendants were sentenced to 5 years imprisonment without an option of fine.
Mr. Lange, sorry to interrupt you, but could I please ask you to start wrapping up, please?
Oh, very well. I just have like just 2 slides now to conclude. Now, here are the major challenges we've encountered in the course of investigating and prosecuting human trafficking, smuggling of migrant cases. There is lack of cooperation between states, and sometimes even if there is cooperation, sometimes there are delays in responding to mutual legal assistance. Now, in the first case that I mentioned, that is Federal Republic of Nigeria and Olayinka, the UK actually demonstrated some cooperation here. Another thing is that some planning, smuggling of migrant planning sometimes takes a longer period before execution, and tracing and gathering of relevant pieces of evidence to prosecute support prosecution is a challenging task. Now, the fraudulent acts and conduct of criminal networks involved in some keeps changing over time, and sometimes it is difficult to detect and to dismantle them. Then another issue is there's lack of parallel investigation and prosecution of those involved. For instance, in the source country, they will have identified somebody, investigated, and there are ongoing prosecutions, where in the destination countries, those involved are not being investigated or prosecuted. Then at the end of the day, you realize that they will begin to look for other persons to engage in the same act. Major lessons we've learned in dealing with this offense. There is the need for all countries to engage in both the formal and the informal cooperation. Like I've said, the UK provided all the necessary documents to us that led to the prosecution in FRN and Olayinka Bello. Another thing is that there is a lot of evidence that the victims and sometimes even the suspect carry in their mobile phones and other apps. So there's a need to engage in digital mobile forensic examination in the course of investigation, because we retracted a lot of evidence in the phones and the devices of those we investigated. And then there is the need for also law enforcement to be more vigilant and to understand the environment in which they work, because the criminals keep changing the fraudulent acts and conduct. Then lastly, there should be parallel investigation and prosecutions in the source, transit, and the destination country. This, we think, will go a long way in coping the menace of smuggling of migrants. Thank you so much.
Thank you very, very much, Mr. Lange and Mr. Kuta. And thank you indeed to all of our experts who have spoken through this morning. We've had a number of questions related to points that have been made, recommendations and so on, and there has been a lot. What we will do is to make available the recording of this session and the reports of the papers, links for those that have been mentioned, the presentations that have been shown on screen. All of these things will be made available to you, and you'll be able to find further information on the meeting webpage for our Intergovernmental Working Group, which shortly starts again in the same room at the UN in Vienna. So the link is going into the chat. But again, thank you very much to all of our expert panelists. I just note, we do have a very tight time restriction. We do have to end for what now needs to happen here. But further to the very specific recommendations made, particularly on the second topic by our speakers, I would just like to return to our first topic and to give our speakers one last opportunity on the non-punishment issue to make a point. I did have specific questions for you, but in the interest of time and also to make the most of your contributions, I would simply give you the floor for 1 minute, please. I'm sorry, but 1 minute only to make whatever point you would like to really underline on this issue of non-punishment of trafficking victims. So Maria, if I may, can I please pass the floor to you?
Thank you. Well, my last point definitely would be that non-punishment provision, even it is not strictly recognized in some international documents, it is international obligations, and governments are obliged to implement it effectively. And we need to have measures for effective implementation. That is the only way we can prevent victims to suffer more than they used to suffer in the trafficking chain. Thank you.
Thank you very, very much. Dr. Malali, can I pass the floor to you?
Thank you very much. I would just reiterate those points. The principle of non-punishment to victims of trafficking is core to the object and purpose of the Palermo Protocol to protect and promote the human rights of victims of trafficking. Without that, we risk trafficked persons being punished and prosecuted. That doesn't help us with the objective of combating impunity, and it also doesn't help us with our objective of assisting and protecting victims. Early identification is key, training and effective implementation, and there I think it's useful to have guidance, direct guidance, to ensure that all those engaging with victims of trafficking know how to respond to ensure effective implementation of the non-punishment principle, including in conflict settings, including with regard to serious crimes, and including in the full range of unlawful acts. And we have plenty of recommendations and guidance on that. So now we really need to focus on strengthening implementation. Thank you.
Thank you very much. And finally, Dr. McAdam.
Thank you, Martin. Very difficult to add to those comprehensive points made by my colleagues, except to reiterate them. I will make the point that I understand some states parties have concerns about how to implement this principle and question its utility in counter trafficking. I would say to them, they need not be scared of this principle, that the principle at its heart is about making sure that we don't punish people who are not responsible for the acts with which they could be punished. And so that is a worthy part of a comprehensive counter-trafficking response that they need not be afraid of. Rather, they need to unpack it, as Professor Mullally says, as both core to protection and assistance of victims, but also integral to ending impunity for traffickers. And so the best results can be achieved by, in earnest, approaching this principle as a key part of making sure that we are applying it on a non-discriminatory basis to all victims of trafficking, regardless of the unlawful act for which they are involved. And in so doing, we can hopefully increase our capacity to address trafficking in a meaningful way that's not targeting the wrong people. Thank you so much.
And thank you. And thank you again to all of the speakers, all of the experts, all of those who have joined. We really want to contribute to and continue to build a culture, a network of people who are responding to these issues. This is ongoing work, and we really wanted to underline that this is ongoing work on the need. There's a need for ongoing exchange. That work continues, and it continues again this morning in a formal setting of our Intergovernmental Working Group. So thank you all again. Hopefully nothing stops. Hopefully we only continue. But thank you again for all of your efforts. I wish you all very well today and in your ongoing work. And we hope that we can join with you again soon. Thank you.
Thank you.
Thank you so much.